Please be seated. This is the time for oral argument. In our consolidated case numbers 1 CA CV120831, 130697, and 140372, I take it there hasn't been a 2015 appeal, so I think we'll just limit it to these three. White Mountain Health Center versus Maricopa County, and William Montgomery, state of Arizona, as intervener appellant. Each side's been allocated 20 minutes for oral argument. That means the state and the county have 20 minutes between them. You can allocate that any way you want, but you have 20 minutes. If you want to reserve any time for rebuttal, you may do so, but the clock on the podium will indicate how much time you have remaining, including your rebuttal time. So you have to manage your own time. These proceedings are being audio and video recorded. And in a couple of weeks, I understand that you'll be able to watch yourself on YouTube. But to help us with that, when you first approach the podium, please identify yourself and the county and the client you're representing before arguing. You should also be aware that we have studied the briefs in this matter, have been reviewing the law, we understand the facts, and you can guide yourself accordingly. We're up to date, I think, on the issues and the facts. So, this probably won't matter, but even though you've been allocated 20 minutes per side, if you're done speaking and you don't have anything else to say, and we don't have any further questions, feel free to sit down. Somehow I don't think that's going to apply here, but with that, counsel for the appellants.
May it please the court. I'm Thomas Liddy of the Maricopa County Attorney's Office, representing appellants Maricopa County, and Wayne Montgomery, the Maricopa County Attorney. Seated at the table with me is Wayne Peck, also a county attorney, and he's our office's primary land use counsel. I'm prepared to argue on behalf of the county in this case, but should the court determine that it could benefit from input from Mr. Peck, he's available to you. I'd like to cede 5 minutes of my time to Mr. Gruby, who is here on behalf of the Attorney General. Also, I intend to reserve 5 minutes for rebuttal if necessary. This court should reverse the decision of the trial court for the following 3 reasons. 1, the Arizona Medical Marijuana Act, AMA, did not affect the general grant of zoning authority from the state to Maricopa County. In fact, AMA reaffirmed that grant. Local governments have the zoning authority as it relates to medical marijuana dispensaries, expressly under AMA. Number 2, the trial court turned permissive zoning on its head. Maricopa County's zoning ordinance specifically lists all uses that are permitted in a specific area. Any use not listed is prohibited. This is permissive zoning. By striking down the second text amendment, the trial court allowed medical marijuana dispensaries to cite themselves wherever they wanted in unincorporated Maricopa County.
What was your third point?
I'm still completing my second point, Your Honor.
Okay, well, go ahead and spend your time on your second point.
Well, as I was saying, that the permissive zoning was turned on its head when the trial court struck the second text amendment and then ruled that there was no zoning whatsoever in unincorporated Maricopa County so that medical marijuana dispensaries could cite themselves wherever they wanted. And specifically permissive zoning in the Maricopa County ordinances, if the use is not listed in that specified area, it is prohibited. The third point, Your Honor, is that the court erred because a legislative act, such as zoning, is presumed valid, even when the reasonableness of the zoning is fairly debatable. It carries that presumption of validity. The trial court ignored uncontroverted expert testimony in the record, specifically as to the reasonableness of the ordinance, by substituting its judgment for that of the Board of Supervisors. The trial court, in effect, sat as a super zoning commission or super zoning board.
Let's begin with your first point. You say that the AMMA affirms the county's zoning authority, and to some extent I think that's hard to debate. The real question is it the county's position that the AMMA has any force of law at all, or is it just completely preempted?
We believe that the AMMA is preempted.
So it's a nullity, and are we basically rearranging chairs on the Titanic because this whole law doesn't matter?
Well, the law matters. It's the will of the people. The question is whether or not it can coexist with the federal scheme that's been set up in order to provide medicines for citizens in a safe way.
Well, I understand that, but I guess my question is, as we evaluate the county's arguments, do we begin with the understanding that the county is going to do its best to comply with the act, or do we begin with the understanding that the county believes the act to be essentially a nullity because of preemption and doesn't believe itself bound to comply?
Well, the county does feel itself bound to comply for two main reasons. Number one is it's the law of this case that the AMMA is not preempted, and so we sought a stay. That stay was denied. The court ruled erroneously that the medical marijuana dispensaries could cite themselves anywhere they wanted, so the county was required to act, and so they put in the third text amendment.
But the second and the third text amendment both contain provisions that, as I read them, are self-defeating. In other words, they make it impossible to establish a compliant dispensary.
Not if AMMA is not preempted, as the court ruled. If it's not preempted, then the inclusion of the language federal in the second text amendment is not a prohibition on citing of medical marijuana dispensaries in unincorporated Maricopa County.
Do I understand then that if there's a final ruling on preemption, the county would then allow dispensaries in the areas prescribed by the second or third text amendment?
Yes, Your Honor.
Okay.
That's correct. If the county loses on the argument of preemption, and I understand that after Reed, this court may feel bound to stick with the finding of preemption, and we would like to fully brief that before the Supreme Court if the case goes on. We believe that they did not have a full record. But even if the county loses on preemption, the county prevails on the issue of reasonableness in the zoning.
Right, okay, but let me back up. I understand that. Let me back up a second. I want to make sure I understand what you were saying in response to Judge Swan's question. If we, and let's assume for our purposes here, if we affirm on the preemption argument and say it's not preempted by the Controlled Substances Act, are you saying that under both the second and third text amendments, the idea of the poison pill, meaning you cannot be in violation of federal law, would not apply to medical marijuana dispensaries that are in compliance with AMA?
Not exactly, Your Honor. If the county does not prevail on preemption, then our position is we prevail on reasonableness of the second text amendment.
I'm sorry to interrupt, but we have limited time. If the county does not prevail on preemption, does the county interpret the second text amendment, or the third for that matter, to allow dispensaries to exist? Because as I read those amendments literally, nobody's saying that these dispensaries are in compliance with federal law. Some are saying they're in compliance with state law. So how is it that if you prevail on preemption, the second or third text amendments would allow any dispensaries?
Well, Your Honor, that's exactly the point. If we fail on preemption, then how does a prima facie reasonable requirement to abide by federal law stop a medical marijuana dispensary from applying for a use permit? If it's not a violation of federal law because there's no preemption, then we move forward with the text of the Second Amendment.
In violation of federal law. And the federal government can come in. Part of the argument on preemption is, can the federal government, if they wanted to, still enforce the Controlled Substance Act regardless of the AMMA? And I think the answer is, barring the issue about the Appropriations Act, that they can. For preemption analysis purposes, they can. So what we're trying to hone in on here is put aside the other aspects of reasonableness for a second, the evidence about reasonableness and where you zone it. There's a poison pill in both text amendments. The poison pill says, whatever else you're doing, you can't be in violation of federal law. Now, does the county interpret that? If we hold that there is no preemption, does the county interpret that as saying it is still medical marijuana dispensaries in compliance with the AMMA are banned because they violate federal law?
I think that's a fact question that would have to go if there's an application.
That's a question of the county's position, because what you've expressed here today, I think, may be a different interpretation of these text amendments than we have been understanding from the briefs. And it's important because I'll tell you candidly that if the federal language were disposed of by a preemption ruling, I might very well be inclined to agree with you on reasonableness. But if the federal language means that none will ever be allowed and the entire amendment is simply a circular exercise, a cute way of saying we're never going to allow any dispensaries, that's a different problem. So we need to know how the county interprets its own amendments.
Now, I think I understand what your question is. Our position is that in light of Reed and in light of this court's future ruling, should you find preemption, that it's now questionable, a fairly debatable question, as to whether proposed use for a medical marijuana dispensary is in violation of federal law. I don't think it's clear that it is a violation of federal law. It's another reason why the trial court erred. It assumed that federal law rendered the zoning ordinance is unreasonable, and it never examined that aspect of the issue. The first thing the trial court said was it's not preempted, and then they said because the language federal is there, it's unreasonable.
But are you saying under either scenario, either preemption or no preemption, the county, isn't that your bottom line, is the county can still ban dispensaries?
No.
You're not saying that there can be a complete ban of dispensaries?
Well, technically, Your Honor,
if you wanted to do that, I'm not talking about what the text amendment says right now. I'm talking, could there be a ban? You're suggesting that under permissive zoning, you can absolutely ban. Isn't that correct?
only if it's reasonable. There are some parcels of land.
Where do you get that only if it's reasonable?
Because in the AMA itself,
well, it says if, right? Isn't there an if? You may enact regulations that are reasonable?
Yes, we may enact.
But what if you don't enact any?
And we don't enact any. That's within our purview. But if we do,
then is it your position then that the dispensaries are all banned? That any dispensary is banned?
No, there are nearly 80 dispensaries operating right now, dozens in Maricopa County.
Assuming you had not enacted regulations, would dispensaries be banned from unincorporated Maricopa County?
Yes, because of permissive zoning.
Okay.
But that's not the fact that we have here before us. The county did zone and then rezoned with a second text amendment and then rezoned with a third text amendment. And there's nothing in the record that say that they would not zone for a permissive use of siting of a medical marijuana dispensary. But any zoning has to be reasonable and is perfectly within the purview of any jurisdiction, a county, a state, or a town, to look at a piece of land and say this is appropriate for this use or this is not for that use. And the absence of a medical marijuana dispensary in one CHA is not relevant to the examination as to whether the second text amendment is reasonable.
But, and I apologize, but I had read your briefs and the county's position to be that regardless of preemption, if the county had this provision that says no use is permitted, which would be in violation of federal or state law, and because, regardless of preemption, because federal law prohibited use of marijuana for any purpose, except for research, limited research purposes, then the dispensaries would be in violation of federal law.
I think in light of Reed, that's now in questionable interpretation.
I don't know that Reed reached the question whether the dispensaries are in violation of federal law.
That's a fair point, Your Honor. They reached the conclusion that it was preempted.
Well, that the state law was not preempted.
Correct. That the state law was not preempted.
But that didn't mean that it wasn't preempted because everything was honky-dory under federal law. It just meant that the federal and the state laws addressed two slightly different spheres.
That's correct, Your Honor. And in Reed, the court held that the federal government cannot require the state to enforce federal law. In our instant case here, we're not attempting to enforce federal law. We're trying to protect our employees to prevent them from violating federal law, which is a separate issue as to whether or not the second text amendment, or the third for that matter, would permit the citing of a medical marijuana dispensary.
That's your impossibility argument under the preemption, right? That, gee, we can't comply with both. We'd be subject to prosecution.
That's correct,
That's
Your
a
Honor.
preemption argument.
That's correct, Your Honor.
So after Reed, let's assume Reed stays good law, and after Reed, if a dispensary comes to you and says, great news, we found a building in an IND3 zone, and we want to submit our application, we want the county to acknowledge that we would be in compliance with all county zoning regulations, would it be, or would the county still be able to say, no, this violates federal law, it's not in compliance?
I think that's it's questionable after Reed.
So,
I don't know the answer.
Okay, you don't know?
No, not
that's
after
fair
Reed.
enough.
I don't know.
That's a fair
I would say-
answer. I don't mean to put you in an impossible position, but I do want to know if we've interpreted your briefs correctly. So what you're saying is that remains an open question under Reed and the second text amendment.
That's correct, Your Honor, and that we have a process in place, and an applicant can come, seek a use permit, and they would go through the procedure. And our point is the second text amendment is reasonable, it's presumed reasonable. Thank you, Your Honor. I've got 5 minutes left. I'd like to cede to the state.
Wait a second, Mr. Gruber. Hold on a minute. Let's add 2 minutes to both sides. So before you start, let's reset the clock.
I assume for the purpose of allowing 2 minutes of rebuttal.
Whatever, however they want to use it.
Fair enough.
And then 2 minutes on Pelle's side. Thanks. Just give us a second here. Very good. Thank you.
May it please the court, good morning. My name is Charles Gruby. I'm an assistant attorney general and senior agency counsel. I represent the intervener, state of Arizona, ex-rel, the attorney general in this case. We intervened on the sole issue of whether the Arizona Medical Marijuana Act is partly preempted by federal law, and the related issue that a court of equity should deny its relief to any business that would be in violation of federal law from day one. Our position on preemption has always been different from that of the county in this case. We believe that not all of the Arizona Medical Marijuana Act is preempted by federal law. We believe that you start with the proposition that all possession, cultivation, distribution, the familiar litany of activities related to marijuana are categorically prohibited by federal law. The fact that the current administration and the current Congress has decided not to take a strong position enforcing those laws does not change the fact that for more than 45 years, the Congress has categorically forbidden all of those activities, and they haven't changed it. They, in fact, the federal government, have, as we showed in our briefs, fought back several efforts when people tried to force them to reschedule marijuana, including as recently as 2013.
And I assume what you're talking about, the current legislation, current Congress, the idea that no federal funds may be used to enforce the Controlled Substance Act if the conduct is in compliance with a state medical marijuana act.
I actually read that, Your Honor, and that's what I referred to. I actually read that a little bit different. I think what Congress said was don't spend any federal monies challenging Arizona's Medical Marijuana Act. I don't think I read that as a denial of the power of federal officials anytime they wanted to prosecute marijuana traffickers in the state of Arizona.
So you said, let's get back to your main position, what you said, not all is preempted.
Right. And I suggest, Your Honor, that the line has to be the following one. Those provisions that actually authorize persons to violate federal law must be preempted under the doctrine of obstacle preemption. What's that mean as a practical matter? Well, we don't think the issuance of identity cards when people comply violates the purposes of Congress. That just identifies for state law purposes the people who are not to be prosecuted by state officials. On the other hand, there are specific provisions, and we cited them in our brief, I'll go into them in more detail if you like, that appear to authorize people to cultivate and manufacture and distribute marijuana, to authorize them to do so. We believe that's preempted, that the state cannot set up a state-authorized system of cultivation and distribution of marijuana.
Your major case on that is Emerald Steel.
It's Emerald Steel, Your Honor, although it's a familiar obstacle preemption analysis. It's from Arizona versus United States and many cases before that.
That presupposes then a view that the federal government, or that Congress enjoys plenary jurisdiction to impose those rules on every such activity within the state of Arizona. Is that your view, that Congress has that broad an authority?
Yes, Your Honor.
And could then preempt the entire Arizona criminal code by enacting its own?
Perhaps not, because, for instance, the chief challenge to the Controlled Substances Act in this sort of setting was the Gonzalez case that we cited in the briefs, where basically what happened was there was a Commerce Clause challenge to the power of Congress to reach in and tell California that they couldn't have a medical marijuana act. And the court took that very, very seriously and said, no, Congress's power reaches that far, because when you're talking about drugs, medicines, and the manufacture and distribution of them, you can reach well into intrastate activity as part of the power to regulate interstate commerce. How far that goes? Could they completely set aside the entire government of the state of Arizona? Well, with your permission, Your Honor, no and hell no. There's a 10th Amendment and an 11th Amendment.
Yeah, hopefully we'll never have to find that out. But it is an interesting position for the state to take, given that the state finds itself at odds with the federal government quite often on issues that could fall within the Commerce Clause authority.
And it's case-by-case analysis, both practically and as a matter of law. You know, I've impeded on my colleague's rebuttal time. May I address another question, or may I yield?
I don't have any questions.
Thank you, Your Honor.
Good morning. May it please the Court, Emma Anderson for White Mountain Health Center. I'll be addressing the Court's questions about preemption, and my colleague Steve White will be addressing the Court's questions about zoning and potentially attorney's fees, if you have questions. As a preliminary matter, neither the county nor the state has standing at this point to assert preemption. The county asserted preemption as an affirmative defense earlier in this case when White Mountain was seeking mandamus relief against it. Since then, White Mountain has opened. It's up and running. It's providing medicine to patients in compliance with state law. It no longer needs anything from the county.
And one might ask, why isn't the whole case moot?
One might ask that, yes. And in fact, I believe that the questions of standing and mootness relate to each other. And in fact, White Mountain needs nothing from the county at this point because they're up and running. They don't need that zoning form to be signed anymore. And as to the state has no particular interest at this point other than a generalized theory that their own law enacted by the voters is preempted.
Would White Mountain have an interest in knowing that there is some certainty regarding the zoning, that it's valid zoning?
I would ask Your Honor to direct that question to my colleague, if that's all right.
Sure.
Well,
Yes.
I mean, the state still has to regulate dispensaries. And doesn't that mean that White Mountain is still at risk? In other words, the state could come in and say, has to sort of, if they say, well, gee, you know, we can't regulate this because we'd be in violation of federal law. So doesn't that make the preemption, or give at least the state standing?
Well, the state has been regulating through the Department of Health. It wrote rules. It has been supplying licenses, identification cards to patients. It has been regulating, and it doesn't seem to have a problem with that.
But I assume it has a continuing duty to register. I mean, if White Mountain, and I'm not saying this would happen.
Sure.
Hypothetically, if a dispensary that was up and running started just selling marijuana for non-medical purposes, the state, I mean, and presumably the county, would come in, and state would probably take away its certificate, and the county could start arresting people because it was in violation of the AMMA.
Certainly.
So to that extent, and I assume the county also has duties on making sure you're code compliant with building codes.
At this point, Your Honor, White Mountain doesn't need anything from the county. It's up and running, and to the extent that it has to annually renew its registration certificate, that's a process that doesn't go through county officials.
No, but I assume it uses the sewer. It has a roof.
Yes.
These kinds of things are going to involve county authority, right? And some of that may be impacted by county zoning.
So, example, assuming the county said, well, gee, we can't really certify that you're in compliance with code because you're in violation of federal law. That gives them standing to argue preemption, doesn't it?
That would give them standing, Your Honor, but at that point, that's a new case. That's not those aren't the facts before you right now, and that's not the controversy that previously existed in this case and at this point has evaporated. Turning to preemption, to the extent the court has concerns about preemption, it turns on Congress's intent, and the overwhelming weight of its actions indicate that it did not intend to preempt the AMMA. First, in 1970, when it enacted the CSA, it included an anti-preemption provision, Section 903, and it specifically disclaims its desire to preempt state law, except in very narrow circumstances.
Counsel?
Yes.
We appreciate, I don't want to interrupt you. We appreciate, and if you would like to summarize in a minute or two your preemption argument, that would be fine. We're more interested, actually, in the zoning issue.
Certainly. At this point, I think the most important preemption point is that Congress has most recently spoken with the Rohrabacher-Farr Amendment, and that prevents the use of federal money to come in and stop Arizona from implementing its own state law. That particularly names Arizona, and I would suggest that it uses the word authorize. And to the extent that there's some disagreement about whether decriminalization and authorization have some constitutional distinction, Congress's use of the word authorize in Section 542 makes that argument no longer relevant.
And Congress could always amend the law to say, you know, we do intend to preempt the entire field.
Absolutely. And at this
would
point,
that be fatal to White Mountain's position if it did so?
well, every preemption argument, of course, turns on the specifics of that case, and we would have to examine what that new preemption language was. But certainly if Congress wants to come in and expand the scope of the CSA's preemptive effect, it could do that. And in fact, it hasn't done that, while almost half of the states at this point between 1996 excuse me, and this year now have medical marijuana laws.
But we can only deal with the statutes as they exist now.
Certainly.
And so I'm assuming that your argument, not to put words in your mouth, but that your argument, besides the federal money, the appropriation and the exemption, and there's no express preemption in the statute, is that Reed-Callagher applies.
Reed-Callagher certainly provides this court with important guidance. I would not suggest that it disposed of the question of dispensaries being preempted or not, but it definitely provides guidance.
It certainly relied on Terbeek,
Yes.
which was a zoning case
And
out of
Terbeek-
Michigan, which held that it was not preempted.
Yes, and I would also note that Terbeek specifically disclaimed Emerald Steel and criticized the reasoning in that case as well.
Okay. And, okay.
If you have no further questions and you're more interested in zoning, happy to cede. Thank you.
If you'd like to jump in, sorry. May it please the court, my name is Steve White. I also represent White Mountain Health Services in this case. If there's any particular place you'd want to go, we can go there. My intent was to address mootness first.
Well, yeah, look, since we have limited time, let's start with the proposition that an amendment, whether it's the second text amendment or third text amendment, was read, assuming one could do this, was read to say, because of preemption, that federal law compliance business no longer applies. Okay, so you can go ahead. You're not going to be barred because you're a dispensary, but you have to comply with the rest of the zoning ordinance. What's wrong with that?
What now? And the first problem is, as Judge Gordon noted, that was not the county's position at the trial court level.
No, but that's my question to you.
So the question to me is, that's a very different analysis. Our position would be that it is not reasonable to relegate a medical marijuana dispensary to a heavy industrial use. But that turns on a different set of standards and a different analysis than the one that Judge Gordon did.
Well, given the volume of dispensaries already operating in Maricopa County, why is it not reasonable? And by Maricopa County, I mean within the geographic boundaries, not the unincorporated areas.
Sure. It is our position that it is not reasonable to place a place where sick people go to get medicine between a nuclear power plant and a slaughterhouse. That is not reasonably related to public health, general welfare. And that it is more reasonable to think about, for the county to think about issues about who is going to be going to these dispensaries and zone accordingly. We don't think heavy industrial use is appropriate for medical marijuana dispensaries.
So it's simply a policy view that accessibility should be greater and perhaps more pleasant than the current ordinance allows.
Not necessarily than the current ordinance allows, but that the second text amendment allows. The current ordinance has had a couple of additional dispensaries apply to the county. They were given approval by the county, and additional dispensaries are up and operating under the third text amendment.
Well, there are a number of, but where are they?
In unincorporated Maricopa County.
Obviously, because it's county approved it.
Yep.
But and CHA 49 has no relation to this, right?
This is in addition to CHA 49. Since White Mountain opened, there are at least 2 additional dispensaries that have opened under the third text amendment.
And they're in different CHAs?
They are in different CHAs in different parts of the valley.
Okay, and they're not the ones that are near where White Mountain's located?
They are not in the same geographic area. One's closer to Chandler, and the other, I can't remember where the other one is. But there are other ones that have opened under, which is...
What makes it unreasonable under the second text amendment, or even, okay, under the second text amendment, that there are 2 or 3 dispensaries, not in unincorporated Maricopa County, I take it, but within 2 or 3 miles of where White Mountain is? I mean, we looked at the county referred, I think it was the county, maybe it was the state, referred us to weed maps. And we took a look at weed maps, and there were 3 or 4 that seemed to be fairly close to Sun City. Why is it unreasonable for the county to say, okay, it's industrial 3, and there is no industrial 3 in this area, but we know that within 3 or 4 miles there are 2 other dispensaries?
2 points. First, I would caution against anybody relying upon weed maps for zoning information. Those are not all dispensaries, right? So they're not all operating in compliance with the Department of Health Services.
So the 3 or 4 that were identified as medical marijuana dispensaries may be illegal?
What I'm saying is, and I don't specifically know what the court is referring to, but what I'm saying is weed maps generally, if you pay to be on weed maps, you can place your business on weed maps, whether or not it's been approved by anyone.
Okay. So what was your second point in response?
So the second point is, as to White Mountain, that effectively is a complete ban anyway. If you relegate White Mountain to heavy industrial, there is no heavy industrial in CHA 49.
But why
is a CHA relevant at all?
Why does there have to be?
Because the state overlaid on the state of Arizona this map, and they allocated dispensaries to be spread out.
This is confusing to me, I have to admit, because when we looked at the first set of regulations, it seemed like if there was more than one these were the ones in like June of 2012, it seemed to me that under 302, that if there was more than one qualified applicant in a CHA, the DHS would use an allocation system like a lottery and just award one, which would seem to indicate that you can't have more than, not that you have to have one in each CHA, but you can't have more than one. Now it looks like that's been repealed, and it's you can have various numbers of dispensaries in a CHA. Why are the CHAs even important at this point?
The CHAs are, well, I don't know that any of it is important at this point. The CHA was an initial allocation system rather than a requirement that these places remain in the same place. What has actually happened since 3 years after the original dispensary certificates were allocated, dispensaries were permitted to move. The Department of Health Services has taken the position that a fairly liberal position on allowing dispensaries to move out of their CHA and into other CHAs.
Okay, but we have to decide this case. Is there any reason that the acronym CHA should appear in our opinion at all?
Yes.
Why?
Notwithstanding the fact that in the joint stipulated facts, both and two instances, at least two instances, the parties agreed that CHAs have nothing to do. It's wholly irrelevant to zoning, is the quote. Wholly irrelevant to zoning, and it's not a requirement that there be a dispensary in every CHA. So why should we put CHA in the opinion?
That was somebody's position. It's not necessarily so.
That's not a concession?
No, it's not.
How could it be a stipulated fact? I mean, we're talking about a statute or an ordinance. It sounds to me like it's a conclusion of law, and which would be a concession.
The stipulated facts included things like the county had an expert, an employee of theirs, who gave a number of opinions. Those opinions appeared in the stipulation of facts. The county attorney, Mr. Montgomery, had a number of opinions that appeared in the stipulated statement of facts. We're stipulating that those opinions were rendered.
So why do we need the word CHA?
I don't think you need the word CHA. I don't think you need to decide anything about the second text amendment at all, frankly.
And why is that?
Because I had this conversation with my client who asked me the question, what happens if we lose on the zoning issue? And my answer was nothing. Because even if we lose the question of whether the second text amendment was unreasonable, they still are open. They've been operating for more than a year, and they exist as a non-conforming use. The county can't retroactively ban them through a subsequent change in the zoning ordinance. He then asked the questions, what happens if we win?
What if we reverse Judge Gordon's order?
Right, if we reverse him, the second text amendment takes place again. I mean, isn't it the case that White Mountain essentially opened at the risk of the second text, of us reversing?
No, White Mountain is open and operating under a third text amendment, which does permit them to operate where they are operating. So what would have to happen is that and we've seen this in a couple of cases where municipalities subsequently change a zoning ordinance to not allow somebody to locate where they are currently located. Yeah. That doesn't mean they have to leave. Yeah. That just means that there is a different body of laws under which they must operate.
Technically, the way you got to the DHS was because Judge Gordon said the county doesn't have to issue anything.
Judge Gordon did order the DHS to...
said this will act as the zoning certification for DHS to process your application.
Yes.
Now, you may be operating now under the third text amendment, but technically you were able to get your client, as I understand it, was able to get the permission from DHS because Judge Gordon said the zoning requirements have been met.
That was originally true. In one of his minute entries, he did order the Department of Health Services to process the application without the approval letter.
Right. So why couldn't the county come back in now and say, well, if the court reverses Judge Gordon on the second text amendment, we go back to the second text amendment, and you're now Isn't your client at risk?
My client's not at risk, Your Honor. The client has gone through the process of getting permits, doing a build-out, getting inspections and subsequent permits, and then spent a significant amount of money, which vests a property right in that client.
But we have to decide whether don't we have to decide whether Judge Gordon was right? We can't just say this is a moot case.
I don't agree with you, Your Honor. And the reason is because what the county's asking you to decide is whether or not a previous zoning ordinance is reasonable under the AMMA. That's not the ordinance under which all of the dispensaries in unincorporated Maricopa County are currently operating. So we're actually at this point they're asking for an advisory opinion. We don't need the Second Amendment to be reasonable in order to continue operating.
But if we dismiss the appeal as moot, the county could come back, reinstitute the second text amendment.
The county could do that,
and then come after. I mean, I don't know if they could make you leave, but it could affect your ability. I mean, for instance, they do have to still inspect your premises.
They do.
And the state has to be regulating you, so they still have a preemption argument, don't they?
They do. We would be a non-conforming use if they went back to the second text amendment, and so we would continue to operate. The people that would affect were any dispensaries who are trying to locate in unincorporated Maricopa County from now forward, if the ordinance changed. That would be a different case for the trial court and for this court.
So are you suggesting that we might have to issue a decision on preemption, but not on the zoning?
Yeah, I don't know that you have to address preemption either, and I'll defer to co-counsel, but I don't believe that the county has standing at this point to make that argument anyway.
Other than a standing argument. If we set aside okay.
So you'd have us issue no decision at all?
Your Honor, whether or not, in our opinion, whether or not we win or lose on the reasonableness of the text amendment, that doesn't affect these parties at all, which by definition makes the argument moot. What we're talking about is a previous text amendment, a previous zoning ordinance under which nobody's currently operating.
Is there any reason to try to give some guidance going forward on to municipalities and counties that are probably wondering what on earth they're supposed to do with, I mean, it seems a bit unsettled, this area. I mean, we have the county maintaining that, permissive zoning means that we can say nothing, essentially. We can have one line in our code that says, unless specifically authorized, then no uses shall occur. I mean, to all the way to, comprehensive sort of, I mean, I assume there's jurisdictions out there that are probably passing something way more comprehensive. Is there any guidance out there?
So normally I would say it is important to give guidance, but frankly this is an issue that only resides with one municipality in the entire state of Arizona. So it is the unincorporated Maricopa County that is creating the need for guidance because they somehow need guidance. And
whether there are no other counties that have unincorporated areas that might have restrictions saying we're not going to allow medical marijuana dispensaries within the unincorporated areas of the county?
I'm not aware of a single ban like Maricopa County's ban in the entire state of Arizona.
Well, and technically Maricopa County didn't have a ban, except for the federal.
They had a ban.
The federal state.
They
did have a ban on
right.
the federal, on the poison pill.
Yes.
But as far as industrial 3, there were areas of industrial 3.
In unincorporated Maricopa County, yes, but I would suggest that might be the area upon which the court, if the court is inclined to give guidance, is related to this poison pill that allows them to argue preemption and re-argue preemption and re-argue preemption every single time somebody presents something to the county. They could make the argument whether or not it's been fully briefed and is before this court, they can still make the argument that they are not required to sign a authorization form on local zoning ordinance because of that poison pill. And that was clearly their interpretation before the trial court, and it was clearly the basis for Judge Gordon's decision, and also largely the basis for the attorney's fees award as well, and the sanction. I see my time's ending if you have no further questions. Thank you.
Thank you. Anything from your co-counsel? Anything else? Okay.
Your Honor, so a couple of brief points. Number one, at the time White Mountain commenced its use, its current use, there was a valid zoning ordinance in effect, so they would have a vested right. So the decision overturning the trial court would not affect their rights to continue to operate unless they wanted to expand to a non-conforming use. When the judge's largest error.
Wait, if that's the case, why wouldn't we just dismiss this as moot?
You can't. I would argue that you don't dismiss it as moot. It's not moot because what the trial court did was take away a very valuable ability of the county to reasonably zone permissively.
So is this capable of repetition yet evading review?
Well, it is. It's a very important public issue which is likely to recur.
Well, I can see where it could reoccur.
Sure.
I mean, it reoccurred in the third text amendment as far as the poison pill. But why would it be evading review? I assume that if the county went back and either applied the poison pill, and you understand what I mean when I say the poison pill, or went back to saying we're going to ban or limit it to industrial 3, an applicant could come in and sue again. Why would that be evading review?
The court found that using the words federal and state was a violation. That was they found facial invalidity, and on its face, that's reasonable. There has to be an application for someone to use industrial 3, and there never was.
So the county is urging us to issue an opinion on this in this case.
The county is, and to overturn the ruling of the trial court so the county can have the reasonable tool to permissively zone in the future.
Are you saying that the court struck not only industrial 3, but struck the poison pill as it applied to any activity, even though it later amended it to say, I'm only striking things as they apply to medical marijuana dispensaries under the AMA?
They struck it facially, not as applied, because as applied wasn't before the court, because no one, not White Mountain, had ever applied to use industrial 3 land for a medical marijuana dispensary.
I understand that, but I was talking about the poison pill. I mean, the court did say I'm only striking the second text amendment as it applies to medical marijuana dispensaries.
That's correct, Your Honor.
The AMA. So it wasn't saying if organized crime wanted to open a heroin operation on unincorporated county land because state law permitted it, assuming that there was an initiative, or there was it wasn't striking that. It was just saying, I'm striking the poison pill as it applies to medical marijuana dispensaries.
Your Honor, it struck the entire second text amendment.
I understand that, but it later said as applied to, as it affects medical marijuana dispensaries,
yes,
right?
And rule that medical marijuana dispensaries could cite anywhere because there's no ruling.
I understand that's the permissive.
And that's what we're asking this court to overturn.
All right.
Thank you.
Well, counsel, thank you for your time. This was of assistance to us. We appreciate the briefing and the oral arguments. It's helpful. We will take this matter under advisement and issue a written decision in due course. With that, we stand adjourned.